right, good afternoon, and we are back here for this presentation. We're going to be talking about leveraging trial exhibits with technology and using technology in the courtroom. Before we do that, a little bit about myself. My name is Armand Murach. I am one of the partners at the Rossen Law Firm. I've been working in litigation for over a decade, focusing mainly in criminal defense and criminal prosecutions. But I have done everything from business litigation, family law, federal courts, civil rights defense, and those types of different cases. I've also been an instructor at several law schools. I've taught at state attorney's offices, prosecutors' offices, public defender offices. My local bar association is a presentation I'm going to be doing quite shortly. And I've also been an instructor for the National Institute of Trial Advocacy. So let's move on to how creating impactful trial exhibits can help you within your case. That is sort of the utilizing technology and new versions of the old technology that we've may have been accustomed to within the courtroom. So why is that important? So when we're talking about why that's important, we have to take a look at the psychology of how people learn, how people digest information, and how they go into remembering something in the future. We have to remember that the person that is sitting in a jury nowadays is a lot different than the person that was sitting in a jury 20, 30, 40 years ago. We are dealing with individuals that get their information in a very short blast, either through Twitter/X, social media, or just little jabs of information that they get from an internet alert on their phone. We've had, as a population, we've grown accustomed to that. So being able to present information that is easily palatable to a person is sort of key when you're presenting in a trial. No matter how persuasive you can be, the information and how you present it is important. So it's important to remember with trial exhibits, the reason why they're important is because a person can process an image a lot easier than a verbal discussion about that image. You may have heard a lot of times people talking about painting an image of the scene, of the crime, of the negligent act, of the business transaction. And a lot of times it's difficult to paint that image as fast and as effective as the actual image itself can do. No matter how great you think you may be at painting an image, the image itself, a video file, can do that job a lot more efficiently. And in fact, it's actually been studied that it can do it about 60,000 times more efficiently than what we can try to do through verbal descriptions of that scene. Because no matter what you try, you're always going to miss some sort of detail from that scene that you're trying to paint. So a lot of people like to do what's called dual coding. And it's something that's based off dual coding theory. What that basically means is combining different bandwidths together to try to present as much information to someone without having them experience sort of sensory overload. So a lot of times what that would mean is you presenting, speaking, verbally, arguing in a courtroom to a jury, but utilizing visual aids to sort of maximize the amount of information you can present to someone. So that whole painting the scene through a direct examination, an opening statement, a closing argument can be maximized by having an image where a lot of that minutia of detail that someone might want to know about, but you won't be able to present it because you don't want to get bogged down in that minutia of detail is really important. So utilizing dual bandwidths, as it were, sort of two lanes on a highway rather than one, gives you a lot more information that you can push through to someone and a jury to understand. And that sort of leads also to what's called the picture superiority effect. And it's been shown that a lot of times that visual information can sort of resound with someone for a much longer period of time because it's easier for the eyes to process that image and remember that static image more so than a 5-minute discussion about that image and the information that you're trying to convey. So a lot of times it helps to supplement what we talk about. Now, it may seem like an ego downer for a lot of people, like thinking that their words are not going to be memorable to a jury. But a lot of times it's just the way our brains are wired, that a human being can remember an image a lot better than a speech, no matter how entrancing that speech can be, to have that image remembered much easier than not. So really the key in sort of having that information stick a lot of times is you'll hear storytelling. Storytelling is the important part of how verbally we can supplement the image to present the maximized effect of remembering the argument and the facts that we want to present to a jury. And it sort of connects it even to an emotional state. That's why sometimes the best trial lawyers are failed actors, because someone that understands being able to convey emotion on top of the information in a dynamic way with images, video, sound, and speech is sort of the synergy that creates the utmost effective argument that can be presented through trial exhibits. So it's not just the old school, I'm going to go get my poster boards, my 24 by 36 foam boards that I'm going to write and highlight on and present that to a jury. That's not what we're talking about here, because the technology has evolved to nowadays of what can be used in a courtroom to really maximize your argumentative ability in the courtroom. And the design of that for how you present it to someone and and understanding the psychological effects of how the brain works can help you sneakily make that impact larger than just plopping up an image on a screen, on a projector, or on a foam board or poster board to a jury. So it's gone to a much more high technical level to present that information, and also present it in a way that is palatable to the person. So a lot of times when you're looking at more complex litigation, let's say a business litigation where a lot of contracts or Excel spreadsheets are involving massive amounts of data, you have to sort of break that information down. And using trial exhibits is the way to do it in a way that a person can remember it. A lot of people have difficulty with numbers. You always hear people say, oh, they can't remember numbers. The old colloquial for lawyers, like if lawyers were good at math, they wouldn't be lawyers. That sort of rings true for a lot of people, where numbers basically make people not remember things, not be able to retain that information, and why those numbers should be important. And being able to process that information visually through trial exhibits helps the person be able to comprehend, understand that, and make a decision based on that information. Because you cannot depend upon someone to be able to process volumes and volumes of numbers, contracts, paragraphs, clauses, what it may be within those complex litigation cases, for them to be able to remember, weeks or even months down the line when they're deliberating in a jury room, and all they have is those same pages that you presented them, without the argument being able to attach or connect to that person when they're trying to make that decision at the end of that trial, when they're deliberating in a room. And that's sort of the key thing that a lot of lawyers miss, because we don't know what's going on in a jury room. But if you effectively present trial exhibits of the information that you're trying to argue throughout your trial, and most importantly within your closing argument, it creates a sort of safety net for you to understand that the jury understood what's going on through the cues that they present to you, nodding their head to that information rather than dozing off, which is sort of the linchpin where people get scared when it's in terms of people not being able to pay attention for long periods of time and understand when those crucial points within the trial are for them to be paying attention. We know that as lawyers. We know that as trial lawyers, because we're the ones that are anticipating, planning the litigation, planning the steps of who's going to be testifying at what point and when they're going to be testifying to that important information. And no matter what you tell them in opening statements, like pay attention to this witness, pay attention to when they're talking about this fact or this part of the case, a lot of times people will get lost in that story because it's not being fed to them in a way where they can handle it. I used to like to say that, like with Twitter, it needs to be at 120 characters at a time. Now, that's sort of a gross estimation as to how someone is going to be able to process that information, but it's a good guideline of how to sort of spoon feed and slow down the absorption so that bandwidth is not being overloaded. Again, that sensory overload that people can get at any point during a trial. Because when they get to that point of having sensory overload, then they're just going to stop listening and then they shut down. And it's not because they're willingly wanting to do that, but that's just because their brain can't process any more of what you're giving them. So it's sort of that old adage where you're highlighting those important facts, but you have to present everything still to a jury for them to understand the whole picture. So just highlighting may not be enough. So that's why you sort of distill the information, you slow feed it to a jury, you slow feed it to the witness even that's trying to give you and help you during that trial to be able to better comprehend that type of information. So one of those examples here, and I've sort of been talking about this, is when you have something that's a spreadsheet that has 15 million pages on it because it's a corporate document from an SEC filing or something along those lines, and you need to present numbers, facts, figures, revenue earnings, those types of information. Being able to distill that information into, let's say, a bar chart, a pie graph, even a Venn diagram is able to sort of distill information for a jury to understand everything that is in that fact. Because a lot of times your jury, even though it's made up of people of like-minded from the community, not everyone is going to be a business owner that had to do these types of filings. Not everyone is going to be a former criminal defendant. Not everyone is going to be a driver that was negligent and be able to understand information in terms of broken bones, medical bills, or anything else that would fit into that type of understanding that you have to present as a lawyer to a jury through the exhibits that you're presenting. So the key thing to understand of what you're doing when you're doing a trial exhibit is to, first off, not think that the trial exhibit is just an enlargement of what the exhibit entered at trial was. Now, with some caveats, you can't modify a picture with digital enhancements to make it better looking or anything like that without a sort of an expert presenting that to a jury. But realistically, it's taking that information and modifying it into a demonstrative that helps the jury understand the presentation of the evidence throughout the trial. No matter which side you're presenting on, it's something that helps complex data get distilled so it fits into that bandwidth that the jury is understanding. And some of the sub points that you look at when you're looking at this is charts and graphs to simplify complex data. This is what we were talking about earlier, using spreadsheets that are being entered into evidence that present a lot of different information, cell phone records, bank records, business records. A lot of different business entities use spreadsheets. Excel is almost a common phrase when it comes to business litigation, when it comes to cell phone records, when it comes to bank records. Everything is sort of stored in spreadsheets to sort of present information in a neat, patterned way. But it's not the way that we can remember that data. So that's why visualizing that data is beneficial to help a jury understand it, rather than presenting it and arguing it for hours for someone to try to understand all of those pages that you're trying to argue, if that's the type of case you're dealing with. Annotated diagrams are also another important thing when you're trying to do summations or summaries of what's been presented. When you can sort of distill the information down to the nitty-gritty of the important facts, show the jury that you've gone from the large spreadsheets into something that is much smaller and succinct because you're only looking for specific facts that are important to the trial that they're understanding. You clarify sort of the smoke and the basically letting the jury see beyond the trees and see the entire forest in the presentation of the argument that you're doing. And a lot of times this is sort of labeling medical diagrams, medical sheets, or doctor's notes from, let's say, a hospital stay. And those types of sheets, if you're doing those types of medical cases like a medical malpractice or a personal injury case, you'll see that there is voluminous amounts of documents. And a lot of times they're just form-based that have a lot of information on them, and there may be only a few check marks of that document that are important to you. But the fact is, you won't want to present a 8 by 11 sheet of paper that has so many different points of information on it that are not important to you. So you need to somehow highlight that, annotate it, focus in on that information in a trial exhibit. And you can do that in a way that is all permissible under your local rules and under the federal rules of evidence to be able to have a jury understand, oh, all I care about is this was the medication that they were prescribed, rather than talking about what their blood pressure was, what their, what their gait was, what their physical presentation was in terms of how they spoke to the nurse or the attending physician. So a lot of times that breaks down that information into a diagram from whatever source of information, because we talked about spreadsheets, but it can be basically like business records of a hospital. Any type of information can be distilled into a diagram, summarized, so that a jury can understand the pertinent points that you're presenting at that specific point in time. And a lot of times that can be with experts that are going through a lot of different documents to reach an opinion. And it focuses on the specific information that expert says this is what's important. The rest of it is just noise or white noise that is not important to their analysis. And a lot of times it's also something that's important for you, something that is not part of what the argument should be for closing, because it can get a jury to get lost and confused. Now, this is a major type of tactic that sometimes can be used in trials where confusion wins the trial. Now, in that sense, you may think, great, I won my trial through confusion, but that is not something that is actually repeatable in how you present and defend a case in trial, or how you prosecute a trial, or how you present a plaintiff's subversionary case, because you're sort of leaving it to chance that the jury's going to get confused and vote for you. It's better to understand and have a definitive approach to the evidence and information that you're presenting on that bandwidth, to have a jury be able to absorb that information through the different means that you can do it. Timelines. That is a crucial thing, especially in criminal defense cases where there are multiple timelines of events that happened. And a lot of times, this can cause confusion of a jury not understanding or melding two different timelines together to basically come up with their own version of events. Now, you talk to any trial attorney, any seasoned attorney, and they will tell you, you never leave anything to chance to a jury for letting them reach a conclusion or decision, because you don't know what they're thinking. So you always want to spoon feed it to them through these types of trial exhibits so that they understand exactly what's going on. But the thing you want to be careful about is when you're doing this is to do comparisons. And I mean that in two ways: one substantively and one for your own benefit, to make sure stuff doesn't get excluded. So the first thing is sort of before and after comparisons. And a lot of times there's old technologies that this has sort of been around for decades, and how lawyers have gone about that. And we'll talk about that technology portion in a little bit. But a lot of times it's important to show how someone has changed. This is important in cases involving basically personal injury or corporate structure. So when you're dealing with corporate litigation or sort of financial situations in terms of accounts and different accounts being spread over for someone in a family law case, being able to visually show that representation in terms of numbers of accounts, in terms of injuries to a person, how they walk in comparison from before and after through side view videos of, comparison on the difference of how they've been affected, is really sort of the important aspect in determining, a comparison visually. So someone who's never met this person before can be able to interpret how they walked before and how they're walking now. And it's sort of the best way of presenting that type of information. The other thing to think about is also how much of a difference your demonstrative evidence is being presented to a jury. So you don't want to go overboard. You don't want to present this information where it's completely become biased towards the other side, or it's sort of unfair, because you're going to be sort of limiting, or you're just going to be creating objections to yourself and how you present that. So it's important to consider the technology that you're using to effectively communicate these exhibits, which leads us to our next section, which is utilizing courtroom technology effectively. Now, a lot of times, people will come into a courtroom and not know what's available to them, not be able to see anything. They may assume that the TV that is in the courtroom is a flat screen TV, and they can somehow communicate to that by the grace of the courtroom deputy, the clerk, or the judge telling them how to connect into the system and utilize it. The number one thing that is a failure in general, how you're doing that is if you don't know how to use that technology before the trial ever starts, before jury selection starts, then it makes you look like you're an amateur to the jury. Okay, that's something to always remember. So the first thing to always do is set yourself up for success. Whatever courtroom you're in, and there's, it's difficult to present on this because technology is different in every jurisdiction in terms of what a courtroom has to offer. As someone who also, coaches mock trial, I've been in different courtrooms throughout the West Coast to the East Coast. And what one courtroom has, another courtroom doesn't have. What one courtroom does have, another courtroom has something completely different. So it's important to familiarize yourself with the court's technology that you have access to. Check the available tech that you have access to. It's fine for during a pre-trial conference before the trial is supposed to start to ask the judge or ask the court administration, what technology is available to me? What do I need to bring to utilize technology in the courtroom? And who can help me set up that technology? A lot of times that answer is going to come from the judicial administration in your jurisdiction, but it's also can come from the judge. The judge can tell you, we've had success using this. We haven't had success using this. I might recommend this. And a lot of times the judges will want to help you with that because they can probably tell you horror stories of technology not working, jury having to be sent out for lunch or, dismissed for the day early because a wire is not connecting, a system's not transmitting, Bluetooth is not working, Wi-Fi is not working. So there's a lot of different things of how this technology can work and how you need to be able to test it in advance to make sure that whatever you might be connecting to their system, your computer, your projector, your microphones, your speakers, all of that works with the technology that they have in order to make sure that when you're presenting to the jury, it's a streamlined process. Because again, that 120 character type of personality that a lot of people will have because of, the internet, the technology that they consume on a daily basis, they don't like to wait. And when they're waiting, they drift off. You lose their attention, and getting their attention back is wasted time of getting them to try to focus in on something, especially if what you're about to present to them isn't something that is going to be, let's say, the smoking gun on your trial case. It's not going to be the thing that is going to wow them in terms of interpreting the information that's crucial for them to vote for you at the end of the day or at the end of the trial. The next thing to know is to prepare your digital exhibits. So you may have photographs that are going to be entered into evidence. That does not mean that is the only way of presenting that evidence to a jury. You can publish things through demonstrative enlargements. That's in the olden days, or not the olden days, but in the tried and true days, the trial boards that people would present, which is a blow up of a photograph and presenting it that way. Being able to see that the enlargement on a screen works and isn't pixelated is now sort of a bigger issue, since we're not really dealing with film anymore. So the image quality is dependent upon, say, a digital camera, a digital video camera, and how many pixels it has in every square inch, and gets into some hyper technical specifics that you may not think are important until you're enlarging it onto a 70 to 80 inch screen TV in a courtroom, and you're seeing the image becomes blurry because the quality of the camera that was used to take it was not of the highest quality. Does that mean you can't still present it on a digital format? No. But what it does mean is that you're not going to be able to fully maximize an image on an 80-inch screen TV because it's not going to be effective to them. So being able to prepare that digital exhibit and see how good it can look in an enlarged and blown up sense is important to do that. The other thing is to ensure that it's compatible with whatever system you're using. A lot of times, and I've seen this through my own personal use in trial, just because a computer system that's in a courtroom says that it can, do a PowerPoint presentation doesn't mean I can do a PowerPoint presentation the same way that your computer is presenting that PowerPoint. Because of things like add-ons in terms of licensures of what version of PowerPoint you have, whether you have a PowerPoint viewer versus a full-on edition of PowerPoint to do a PowerPoint presentation is crucial to understand. And I can tell you from personal experience, one of the biggest things that I've seen happen to me is having a PowerPoint viewer that wouldn't let me play embedded video. And it was a presentation that was sort of key in terms of timing of playing a certain segment of a video in trial to really make an impact to the jury. It didn't work because it wasn't the right type of PowerPoint application. So what happened is I had basically a minute stall of silence to then manually open up that video file and play it. Now it played, but the effectiveness of it was dampened by the fact that I did not ensure that it was compatible with the system I was using in that particular courtroom. Now, when you're doing this, you may think that, I don't know who I need to coordinate with. Who do I need to talk with? Like I said, a lot of times scheduling something with court administration early on, and I mean not the day of or the day before, but try to contact your court's administration a week on out saying like, hey, I need someone to walk me through this technology in terms of how to get the technology in the courtroom. If it's something that is mobilely based and gets wheeled into the courtroom, how to turn it on. Is there passwords that I need to know to unlock the computer or the smart TV or smart podium that I'm using in order to use it so there's no sort of delay in presentation? Is really important to understand that equipment, because you are not using the equipment yourself on a daily basis. It's someone else's equipment, so you have to treat that equipment with the same type of respect that you would expect someone to treat your equipment if you gave it to them. It's like saying, if someone asks to borrow your laptop and you say sure, handing it to them knowing that there's a password on it and not giving them the password. If you don't ask, same thing. They're not going to tell you because they're just going to assume you may have known what the password is because you're a lawyer and you probably had another case and dealt with someone else in administration that told you how to work it all. So a lot of times asking questions in terms of how to use it. Does it require passwords? Do I need help to present something? Do I need to link something up? Am I allowed to connect this to your computer to make sure that you're not violating any rules within that courtroom? Is crucial to setting yourself up for success. Now, when it comes to that, and again, sort of piggybacking off the term, the best trial lawyers are failed actors, is the choreography for the show that you're presenting. Now, you may think that you don't have to sort of choreograph how the trial gets presented, but a lot of times a jury is paying attention to how well prepared you are and being able to mock up who's going to move and turn on the computer, to turn on a projector, to turn on, an Elmo device or anything else that you're using in a courtroom is crucial while you're beginning a direct examination, while you're in the middle of a closing argument or an opening statement, or while you're in the thick of it in a cross-examination. That's why a lot of times you will see a trial will not have just one attorney. You'll have multiple people in there. You'll have trial tech experts that you can have with you if your firm has an IT department and you want someone that is computer savvy there to be able to help you with the presentation. It helps bring simplicity to the information that you're presenting it and how you're presenting it with the visuals so that they can understand it and move along with it as you're presenting it seamlessly. And there's a lot of ways that this can happen. One of them is, like I said, with someone that's a trial tech person that's going to be moving along the slides. The other one is what I like to call the weatherman approach to it. Now, a lot of times people don't realize that weatherman has a little controller or basically like a presentation clicker in their hand where they're moving through their presentation of the weather when they're doing a weather report. And it's the same way for us as lawyers to choreograph the presentation in terms of what exhibits are going to be shown or what time during the presentation on a direct. But it allows for the understanding of what that storyline is going to be for that case. And it helps to engage the jury because that creative storytelling that you're trying to do, that narrative in how you choreograph your presentation of these digital exhibits and the technology that you're utilizing to present it to the jury is something that you will then be able to sort of modify as you go along. And when it comes to using technology, it's sort of the pro over the old way of just having trial posters and blow-ups of exhibits is that you can easily modify it as the trial goes on. So a lot of times, if you've been practicing for a long period of time, you've probably experienced that anxiety of either having to go to Kinko's or a FedEx office or your printing shop that you get your exhibits from and trying to get a last minute change on an exhibit because something happened in your trial. And now you're expending a lot more resources to get that done rather than focusing in on modifying whatever part of your presentation for your trial that you have to do isn't able to be done. So being able to maintain control of the technology and being able to change it as you go from the presentation is very important. Like even changing the software that you're utilizing because something has changed and it's no longer the best way to present it that way, and you change it at the last minute. Technology allows us to be able to do that and organize information on the sort of the drop of a hat in a different way because of, let's say, the type of jury that you got selected for the trial wasn't what you anticipated. And now you have to change the information because you're seeing a lot of sort of, different type of learners in that case. So it's something that's important to understand when it comes to doing that. So let's get into the nitty gritty of how you present this and what type of tools currently exist for you to present in your trial. Now, a lot of times it's a sort of reimagination of stuff that we've had in the past, and it's not really any different than anything else that you've ever used. But it may look completely foreign because it's utilizing a new form factor, a new format, or a new just type of technology. So why is it important to understand the technology you use and how you present that information? And I like to use the best analogy of this, of sort of leveraging the technology to enhance and amplify your information. You may have the best evidence in the face of the world, and every attorney that you've consulted with tells you, yes, this is the smoking gun for your case. I like to use the analogy that, let's say you're at the most expensive steakhouse in the world. And I apologize if you are a vegan watching this, but I can't think of a sort of a example that meshes with that other than this one. But imagine you are at the most expensive steakhouse in the world and you're ordering the best steak in the world. And you're starving for it. You can't wait for it. You've saved up your entire life for this one meal because you're not going to be able to afford it again ever. If that's the type of meal that I want you to visualize. Now imagine that waiter comes up to you and serves it to you on a garbage pail. And that's where this photo is. And I love AI for being able to generate something like this. But imagine getting served the steak on a garbage pail. Now, are you still going to want to eat that steak? No, not really. So it takes away from the impactfulness because you're not utilizing it in the right way to present that. So what we're dealing with leveraging technology is enhancing the engagement, allowing dynamic interaction by being able to zoom into something, highlight something. There are PowerPoint presentation clickers that actually will be like a spotlight rather than a laser pointer that will highlight a certain section of the screen using technology and Bluetooth to highlight a specific area or even zoom into that area when you're clicking on that area on the screen. It improves the clarity of the argument that you're presenting, and it helps support, again, like I said, the ability to modify that type of case, whether you need to present something in a hybrid trial, like now the current day and age, we're dealing with a lot of people teleconferencing in for a trial, witnesses, even total Zoom trials. This helps with that type of presentation because you can become very malleable to whatever occurs. Like an expert that you have that's out of state, plane gets snowed in, weather events prevent someone from physically being able to present their information. A lot of times courts nowadays are being very, very willing to allow people to testify via technology like Zoom and other type of form factors, Microsoft Teams, Web2Go meeting, a lot of different ways of presenting the information that with your technology becomes seamlessly transitioned into presenting that to the jury. So the type of courtroom tools that you have to use for that, Elmos. Most people should know what an Elmo is, but it's a document camera that you present some sort of image that goes on the ground, and a camera captures it and presents it through a projector, TV, or another medium to present something to a witness or a jury. A lot of times in a lot of different courtrooms, these are connected to individual TVs within a jury box, within the witness box, and also for the judge and the different counsel tables that may be present in your courtroom to see as well at the same time. There's digital whiteboards. These are a little bit more hyper specialized because it's basically just a whiteboard that can be drawn on, and that image can be saved digitally to be presented at closing argument from someone that draws, different wordings or different images or diagrams on a whiteboard for a presentation. My favorite thing next is smart TVs and smart podiums. Now, a lot of times people may see that in courtrooms they've installed large screen TVs. Now, these aren't being installed so people can watch sports on them. They're being installed so that they can help with presentation. A lot of times I'm seeing it nowadays being utilized for Zoom presentations during regular dockets within a courtroom or conferences. But a lot of times during trial, you may not realize that TV is actually what's called a courtroom smart TV, meaning it's a touchscreen, meaning it's a computer, meaning you can connect a USB drive with your PDF files, your images on there to be able to present it, to be able to play it, to be able to interact with that screen because it's a touch screen, to do whatever you need to do dynamically for your trial. Smart podiums, these are basically all-in-one type of systems that you may have in your courtroom where it is a podium that connects to the wall. It has power running to it, and that's because there's a screen on the podium there where there's a computer with a touch screen, with an Elmo sometimes attached to it, with other types of presentation abilities to present to a jury that you can utilize to sort of present the information seamlessly during examination. Some of these podiums are so smart that you can transmit that image that you have on that computer to the witness box. And have them interact with it while it's being played on a bigger TV or a projector for a jury to be able to do that. But it's important, again, to reiterate what we talked about earlier. Make sure you know how this technology works. Sometimes, even though a witness may be able to annotate, draw on that screen because they have a touchscreen monitor in front of them, it may not save that demonstrative that you have there, that digital evidence that you're trying to present as a trial exhibit to present at closing arguments. Now remember, a lot of times when you're doing these demonstratives where you're having a witness draw on something, you're doing that for a purpose. And that purpose is to present it at closing arguments so that the jury can be reminded about that testimony that they heard about before. Remember, again, I'm going to reiterate this point over and over again during this presentation, but 120 characters. I'm not trying to exaggerate here in terms of how a jury may not remember what you presented to them. And the worst thing in the world you can experience as a trial lawyer, and you may have experienced this already in the past, is hearing that a juror outside after they rendered their verdict saying, "I wish they would have said this," and your jaw drops, saying, "Well, on day 2 or day 5 or day 15 of the trial, that was exactly what we were talking about." They didn't remember it. You didn't have that trial exhibit that was drawn out, that was complicated and distilled down to something simple for them to reiterate and be able to use it again. That is a lost moment, and it's easy to try to save that type of image from the technology just by asking the court admin or the court administrators or the IT support people, how can I save this after they draw on it? Because if it goes away, it disappears. You're left without that exhibit, that trial exhibit to utilize in closing argument or in cross-examination or in any other part of your trial. Trial presentation software. This is sort of one of the first innovations when it came to technological courtrooms, because it's not just PowerPoint. It's not just utilizing different types of software for it, but it's sort of a more specific designed presentation software. So there's two types that I mentioned here: trial director and sanction. What these applications allow you to do is, let's say you're looking at a document and you're presenting it on a screen. Remember, we talked about how an 8x5x11 piece of paper with a lot of terminology, paragraphs, diagrams, and everything like that, it can be sensory overload for a jury. What this type of technology can allow you to do is highlight a certain part of that text on that image that's being shown to a jury, and just basically expand on it and zoom on that section of text specifically for a jury to see. So it does it in a very dynamic way. Like, if you ever seen this technology used in a trial, it basically is you highlighting that portion of a text with a text box, and as if though you're sort of doing a drag on a computer screen to sort of select a group of text, and that just sort of highlights it, expands it, and just draws in the jury's focus in on that. That's the type of technology that exists for use in trial. The old tried and true of audio and video playback. This is crucial when it comes to preparation and making sure that the audio isn't whitewashed because of this type of speakers that is within that courtroom, to make sure the audio plays properly, the format works properly, because a lot of times audio files require certain players. The safest bet for you to utilize for that type of technology is something called VLC LAN, which sort of has what's called the codecs. I'm going to really technical terms here, but codecs are the coding and decoding of audio streams, data streams into video and audio, because those are really just compressed files that are presented within that file format on the computer. So it's important to be able to have those properly work on the systems in the courtrooms that they have. A lot of times sometimes it's as simple as plug and play, plugging in a USB drive that has the video file, and it will play right away. Sometimes it can be even as low level technology as a CD-ROM playing a CD audio file for a jury. But this varies in terms of courtrooms, in terms of what you can use. Even VHS tapes, which is now becoming more hard to be able to present, but a lot of times in older cases, especially in criminal prosecutions that, let's say, have been tried and reversed on appeal, and 20 years later they're retrying a murder case, a drug trafficking case, they're still relying upon that old media. So being able to figure out how to intertwine old media sources into new media playing factors, because some VHS players will not connect to modern TVs. Again, plan for success with the tech tools that you have and with the tech tools that you need to bring to use the tech tools in that courtroom. And most importantly, I can't reiterate enough on timelines and sort of creating animations for a jury to understand. Helps distill the information. Interactive timelines help understand the narrative and the storytelling that you're presenting. And realistically, technology is sort of the only way to do that nowadays, other than having your own whiteboard or a giant notepad and trying to draw it out yourself. That has a lot of pitfalls to it. First off, turning your back to a jury, something you never really want to do. And the second off is the dead silence while you're trying to write, especially if there's a lot of information that you have to write on the timeline for a jury. It's wasted time, wasted space that could be used to better implement that information and make the argument that you're trying to make to a jury in that case. So like I said, plan to succeed or prepare for failure. Test everything in advance when you're presenting with technology. Remember, the government is the one that is funding the technology in a courtroom, and they usually go with the cheapest contract if they're bidding for it, or if they're doing it on their own. They are buying sometimes the cheapest stuff that they can because they're trying to buy from multiple courtrooms, and it may not be designed for longevity. It may not be designed for, the common user that may not know how to use it, bangs it once and breaks it, and it doesn't work. I've seen this with sort of the new modern Elmo presenters. For some reason, the newer versions that are presented within a courtroom that are digitally connected using HDMI or USB-C connections to a TV break a lot easier. And you get to see sort of that, what I call the rainbow screen of death, where there's black and white static with different colors on the screen. It's something that you want to always make sure that you're checking the equipment to make sure it works. And then you're checking to see that if it will play your type of PDF file or your type of JPEG file or your type of a movie file. The thing you need to remember is not all file extensions are made alike. So just because you have a document that says it is a PDF file does not mean that it's going to open up just like any other PDF file on your computer. If you go through and sort of the rabbit hole in terms of these different file formats, you'll understand that it's almost simple to identify any file on a computer as a PDF, even though it may not be an actual PDF, or it's a PDF-A, which is an advanced PDF, which requires a special type of viewer to open that file up, or if it's sort of a complex photo image that requires a special viewer because it has multiple channels. This is a lot of times the case when you're dealing with surveillance videos. There's proprietary file formats for that kind of stuff, so that you want to make sure that if need be, and you can't convert it to something else, that you have the ability of downloading whatever viewer you need in that technology in the courtroom to make sure that you're able to play it. Try to keep it simple. Now, being opened up to the world of different types of technologies and different types of issues that you can show to a jury through video format, through audio format, through presentation software, through zooming in on specific points and becoming hyper specific with each exhibit that you're presenting in the trial, doesn't mean that it's the right thing to do. Sometimes the adage of keep it simple, stupid still applies, because at the end of the day, again, we go back to that bandwidth situation. You don't want that bandwidth to be filled up with all this imagery that you're trying to present and showing, sort of wowing the jury with your prowess of utilizing the courtroom technology when it's not going to be effective in helping them remember it. So remember, it may be fun to utilize the new technology and you learn it and it becomes easy and it's like, great, I wish I had this 20 years ago. Or 10 years ago or 30 years ago. But if it's not being effective to the jury, then why are you bothering with doing that? So always remember, trying to keep it simple, distill the information, make sure you're not overloading the bandwidth. Be prepared for backup plans. Like I talked about with the trial example in my own past of having the PowerPoint software not working. I was able to still present the argument I needed to, even though it wasn't as effective as I wanted to, because I had a backup plan with a USB drive that had the files individually that I needed, rather than having the presentation file work and do it for me. Also, remember to engage the jury. You always talk about when we're doing jury trials of not having any barriers to you and a jury. That's why people suggest that you don't stand behind a podium, why you don't cross your arms, why you don't button up your jacket in the presentation. You want to try to avoid that. And it is a common pitfall with technology that we sort of dehumanize ourselves in the presentation and the emotional impact that we can convey. Like I always like to say, AI will never replace lawyers because AI cannot emotionally connect with a jury to make them want to side with you, right? Technology is a tool to aid us, not to replace us, not to replace the arguments that we're presenting in court. It is there to help supplement it. Remember, we talked about that dual theory there. You're not trying to just completely supplement yourself out, utilizing the visual aids in presentation for the trial. It is there to supplement your argumentation, your verbal commands that you're trying to present to the jury and getting them to side with you throughout the case. And always remember, coordinate with the court. Know what the judge's rules are in using technology. Even though the courtroom may have technology, the judge may forbid you from using certain types of technology. Now, that is, a pitfall that's going to depend on each jurisdiction. That is a housekeeping issue with the courts, whether the local rules permit it. So always check your local rules in that specific courtroom in terms of how technology or how evidence can be presented. Because in some jurisdictions, a court, a judge will stop you from utilizing certain technology because they don't like it in their courtroom. It takes too long to set up. and they sort of have sort of rules that limit that presentation. That is sort of, challengeable in your jurisdiction based on the rules within your own jurisdiction and how you are allowed to present. That, of course, that's sort of being eliminated as we've come out of the Zoom era of trials and hearings, where technology is more being embraced by different courtrooms. But that is something to still consider depending on the jurisdiction that you're doing, which means you have to sort of adapt to it. Speaking of adapting to it, we've talked about it sort of in general, but realistically, every type of trial is different, from criminal, civil, more transactional types of cases that may require a jury, may require trial exhibits to present it. So you have to have different considerations for different types of cases and how you're presenting it. Because, a timeline, like I've stated, works in a criminal case, but doesn't mean it will work in, let's say, a civil case. It won't work in a transactional case. It won't work in an intellectual property case the same way. So let's take a look at some of the different ways you can utilize technology, and hopefully it'll give you ideas in your future cases on how to use technology in your practice. So the first way to look at it is, like I said in this image here, is someone trying to push square pegs through round holes. You can't force the types of different technologies that exist and that you may witness in a trial for different your case and your trial, because the technology may not be best suited for how you're trying to present the information. So a PowerPoint presentation may not be good if you're dealing with, let's say, a stalking case in a criminal matter. May not be good in a personal injury case if it's something that's just a simple crash. It's really matters on the complexity of the case, how you want the jury to interact with that and engage with that evidence, and the type of format of that evidence. Is it a document? Is it a PDF? Is it an image? Is it a sound file? Is it 3D mapping points from a traffic homicide case or a personal injury case that requires a different way of presenting it on a 2D fashion? So there's a lot of different things that can be utilized, and you have to consider when you're utilizing these types of exhibits. So we're going to start off with what's near and dear to my heart, which is criminal trials. Video and audio playback, that is crucial when it comes to utilizing technology in the courtroom. Digital timelines, again, that is crucial when you're trying to present one side versus the other's timeline of events to determine what makes sense, what doesn't make sense. The consideration of forensic examinations or animations that can be presented. A lot of times in different cases, when you're utilizing experts in criminal cases, there may be a 3D animation that is created to sort of understand what was going on inside a room, what was going on inside a car, in a cell, on the street, an overhead sort of analysis of someone driving on a highway speed chase. Those are different ways that technology can be utilized in doing it. A lot of times nowadays is 3D cameras that are mapping a 3D space onto a digital file format that is being utilized to, let's say, reconstruct car accidents, which is also in civil litigation something that's important and can be done. This format is hard to present without using technology. And a lot of times people forego presenting it because they don't understand that they can use a presentation system to present that information to a jury, or use something that's sort of up and coming in different trends, which we'll talk about shortly, to present that type of information to a jury. So in civil litigation, a lot of times what you'll be doing is presenting medical illustrations or x-ray overlays. A lot of times this was done in the past, and this may not seem like something new to a lot of people, but a lot of times it was done through overhead projectors and basically transparencies that were printed on, and then you would overlay each one of them to show, let's say, an x-ray on top of a photo of a person that was injured, to show the impact of the injury to internal injuries, to external injuries, to sort of map that out for a jury. That's sort of been simplified in terms of technology because it can be done in a lot different ways through presentation software, through basically making sure that the image sizes are correct. So someone's skeleton is not larger than their actual photographic body that was examined. So it can be resized and reshaped to fit the exact images, so that overlay can be done a lot quicker than it could have done in the old days of getting the right size transparencies to present to a jury. Financial charts and graphs, we talk a lot about that, spreadsheets and sort of the information that can be presented. You can simplify contract disputes by highlighting specific paragraphs within the contract. A lot of contracts that are in dispute are usually voluminous pages and pages, and maybe even subparts of contracts that you need to present to a jury. Presentation software and digital analysis through PDFs or projectors, TVs, showing that information, make it more palatable to understand, rather than them having to look at that contract in that jury room and try to make sense of it after the fact of the trial. Document cameras and highlighting tools are the basic way of doing that, and sort of the best practice type of technology when it comes to civil litigation. And then intellectual property and complex litigation, where technology really can help distill the information and keep it within the bandwidth for your jury. Being able to present patent diagrams, again, through analysis, through different patents, to be able to overlay the design schematics of something over another, side-by-side comparisons, or live witness annotation, again, making sure that they can draw on that information to distill it and basically present it down to a jury. Now, this technology isn't sort of dead end at that level. There are a lot of future trends of what people are starting to do, and you may have noticed this in sort of the news. Now, these aren't novel approaches. Believe it or not, there are people that are developing technology for lawyers to use in trials to utilize this type of technology, and it's not really a far throw away from the technology that currently exists. The first one is virtual or augmented reality. There's actually been in the news recently where, in a criminal case for a stand your ground hearing here in Florida, that a defense attorney utilized VR technology to present a stand your ground argument. I see this as something that can be utilized a lot of times in a civil case. Because when you think about the standard of the reasonable person, being able to present a virtual reality or augmented reality of what a reasonable person should have done when they were in that same seat, basically almost a golden rule violation without being a golden rule violation, unless the rules of evidence change, but depending on how this technology plays out, is something that can be used. AI can be utilized to help summarize information. Remote and hybrid courtrooms utilizing Zoom. There's technology called Prezi that allows you to present in the screen. So almost you're a weather person within your Zoom screen without having to share your screen to show more information. And then the really scary thing is real-time jury feedback tech. This is basically taking sort of the technology that casinos are using to see if people are stealing or lying, to be able to interpret how juries are sort of taking information into their that you're presenting to them. But this is all down the pipeline that you may have to deal with in the future, and being able to know that's coming will help you with your practice. Now, enhancing your case presentation through these visual aids. Now, you're strengthening your case narrative with the visual text. You're increasing the jury's understanding. You're reinforcing key themes. The themes that you present in opening and closing get really distilled through the presentation of trial exhibits through digital technology to help make that impact, that emotional impact that you cannot forget. It helps you create that by supplementing your own emotion